More on this, I want to bring in Margot Cleveland now. She's a senior legal correspondent at the Federalist and joins us on the phone. Hello, Margot.
Hey, how are you, Vince?
I'm doing well, but my jaw dropped when I heard that. I know she's a left-wing justice, but have you ever heard a justice take up that the First Amendment is designed to protect the government?
That was quite outrageous. She, of course, was saying it in the context of what I think normal Americans would be shocked and want to protect children, where there was some viral video suggesting they jump out of the window. But what struck me most about it was the last part where she said, why can't the government go when there are threatening circumstances in the government's perspective? You know what threatening circumstances in the government perspective is going to be? It's going to be Donald Trump getting reelected, so we have to squash the Hunter Biden story. It is going to be that Donald Trump is talking about a bloodbath when Joe Biden gets reelected to what's going to happen to the auto company. So she actually was, at the end of it, explaining what the consequence was if you follow her theory. The consequence will be when the government, in its perspective, sees something threatening, it then will seek to silence speech.
And the case itself is not hypothetical. These are actual harms that have already been carried out by the government against American citizens, in particular during COVID, when you had Americans expressing views that ran counter to what the government wanted them to say. The social media companies, under pressure from the government, were banishing those views. This actually happened, Margot.
Right, and not only did it happen, but it is the perfect illustration of why the government should not think its perspective trumps. The way you get to the truth is by having multiple viewpoints. And what happens when you, the government, think you know better, you end up silencing truthful speech, not just dangerous speech. So it was actually interesting from so many angles that what the justices were doing was they were posing all these very difficult circumstances, national security, children being injured. But that wasn't the case before it. And it's understandable. They want to know where the limits are of what the policy is and how is it going to apply. But we have facts here that show us, in the main, what the government is going to do with this sort of power. And not just that, what the consequence is when the government thinks that its view is going to control. It ends up silencing the truthful speech, and that ends up hurting the citizens even more than what this supposed false speech would be.
Yeah, Sam Alito was strong on this today, as far as I was able to tell, which is, and he was pointing out that that the government is holding to the head of the social media companies a weapon of sorts, which is that they can regulate them potentially or inflict them with a criminal prosecution of some kind. Here's Sam Alito today during the oral arguments. Stand by. I just messed up the audio. Let me play. Here we go. Sam Alito.
Exchanged between the White House and other federal officials and Facebook in particular, but also some of the other platforms. And I see that the White House and federal officials are repeatedly saying that Facebook and the federal government should be partners. We're on the same team. Officials are demanding answers. I want an answer. I want it right away. When they're unhappy, they curse them out. There are regular meetings. There is constant pestering of Facebook and some of the other platforms, and they want to have regular meetings. And they suggest, they suggest rules that should be applied, and why don't you tell us everything that you're going to do so we can help you and we can look it over. And I thought, wow, I cannot imagine federal officials taking that approach to the print media, our representatives over there. If you did that to them, what do you think the reaction would be? And so I thought, the only reason why this is taking place is because the federal government has got Section 230 and antitrust in its pocket, and it's, to mix my metaphors, and it's got these big clubs available to it. And so it's treating Facebook and these other platforms like their subordinates.
What he's kind of suggesting here is it's almost like a mob-style threat. That's a nice social media platform you got there. Hate to see anything bad happen to it. Is basically the government's implied threat here, Margot.
Absolutely. And he did a really solid job. But I think that there's going to be a lot of education that's needed, because my kind of bottom line takeaway was there were 3 justices who saw a problem. There were 3 justices who thought, oh, this is great. And there were 3 justices who were kind of on the wrong side of understanding what the issue is here. And what I mean by that is you kept hearing the justices talk about coercion. And this isn't a question of coercion. The government has no business asking anyone to silence the speech of a third party, unless there are extreme circumstances, which in the Supreme Court jargon, there's a compelling interest, and it meets this strict scrutiny standard. And here we have to distinguish between what the justices recognize happens quite frequently. You make a call to the New York Times and say, hey, they're going to run this story. This is totally false. Don't publish it. The difference there is the government is going to the person doing the speech. The person speaking, in that case, the New York Times, they can consent, they can waive their First Amendment rights, just like you can waive your Fifth Amendment rights. But you cannot, as a social media company, say, oh, I'm not going to let these other people speak. That you don't have the right to waive their rights, and the government doesn't have the right to indirectly cause the censorship. And the problem was the Supreme Court was missing that distinction. Every justice, for the most part, kept bringing it back to this coercion standard. Now, the coercion standard, they met in this case. You saw the coercion day in and day out from that clip that you just played. But where did our country get this idea that it's okay for the government to go and say, I want you to silence Gateway Pundit. I want you to go and silence this other doctor. And to me, that was really concerning in the argument.
For sure. And we would, if it wasn't the social media companies in any other context, it'd be horrifying if we found out that the feds came in and said, hey, don't express that message in your business, or don't allow someone else to express that message. Like, hey, how about you stay out of this? You have nothing to do with this. In fact, the First Amendment is designed to stop this conversation from happening in the first place.
Right, and that's where, if you think through the example that he was using with the newspapers, and that they would say, no, don't do that. And I think that he was right that it's partly that with social media, they have the 230 protection, they have antitrust protection, but they have another thing that's different. They are not the press. Even though you see the legacy press kind of caving on what their responsibility is, the reason the government doesn't do that to this same extent is because there still are a few journalists there who would be up in arms over it, and they wouldn't publish, they wouldn't cave into the government because they are in a totally separate industry, and there is at least a historical understanding that the government doesn't come and tell them not to speak.
I will say, though, that, Margot, I'm not sure I love Sam Alito's analogy there, because the government does exert pressure on news outlets.
Right, and that's where I'm saying that my distinction is much more significant here. And the distinction here is that the news outlet, you go to that news outlet, the news outlet is more than able to decide whether to waive its own rights to speak.
Oh, I see.
And that's different than when you go to X or you go to Facebook.
Right.
And you ask them to censor someone else. And if the New York Times is going to squash the story, then you know what? The speaker can go to another place and run it. You're going to have the government to get every single one of the newspapers not to break the story in order to squash the story. So there's another incentive for that to happen.
Right.
So that's the distinction that unfortunately the justices did not seem to kind of distinguish. But then you also have the distinction that Justice Jackson was trying to, I think, make, which is sometimes the government can actually suppress speech. Not very often, though. And that's where you have to keep in mind. In those rare circumstances, let's say there is something where the government is about to launch a raid to get the leader of Hamas. Israel is about to do this, and our government knows this, and someone's going to publish it. Maybe in that case, you have a compelling interest, and that limited right, that limited government interest, allows you to push and even coerce the government to censor, the social media companies to censor speech. But we are nowhere in that type of field.
Even there, though, I don't know. I kind of feel like I'm an absolutist on the question. I could be wrong, but to the extent that a newsroom, say, would hold off on publishing information about a pending raid, they would do that as a courtesy out of loyalty to country, not because I don't like the idea that the government would compel them not to share that information. But
right,
instead
and you know what? We can have that debate, and that actually is a good debate to have. I actually still, as much as I keep saying that all the craziness that's been going on the last 6 years has almost turned me into a libertarian, I still cling a little bit to my conservative nature, that I do think that in some cases there is that compelling interest, and that might be it. But we are nowhere near that. And yet the justices seem to think if it's an emergency, if it's in the public interest, or as Justice Jackson said, if there are threatening circumstances in the government's perspective, none of that should matter. The government should, if they want to get on the bully pulpit and say, this speech is false, this speech is true, go ahead and say that. But they have no right, no business telling other people to silence third party speech.
And you don't. And again, finally, just to go back to the point I made earlier, it's not hypothetical. This all actually happened. Masks were not as effective as the government claimed. You had the vaccine did not stop the transmission of COVID. And the idea that it came from Wuhan seems like the most probable explanation for where the thing came from in the first place, from the lab in Wuhan. All of that was stuff that was censored at the behest of the federal government by the big social media companies, and that should never be allowed to happen again. And any system that allows it to happen again is violating the constitutional rights of American citizens and using these big companies as a cutout to do it, I think.
Absolutely. And as you said, not only did this happen, but those three examples you gave show why we need free speech and why we need the government out of it, because all that it does is it will enforce an orthodoxy, and that orthodoxy could be false. So it's exactly right. It happened in very real circumstances, and it's shocking to me, given what the reality was, that it isn't just a wake-up call to kind of reinvigorate the importance of free speech in our government. When you listen to the justices, that didn't seem to be what they took from the examples.
Man, I hope they make the right decision here. Thank you very much, Margot Cleveland, for covering it as always. Really appreciate your time today.